Good morning, everyone. My name is Izzy Greenberg. I run the Middlesex Coalition for Children. We have today a great panel of our resident experts. Meryl Gay and Ava Bermudez-Zimmerman are here with us as always. Liz Frazier couldn't make it this morning. But we also have Danny Livingston, who's an attorney specializing in labor, and wanted to give you guys a chance to ask all the questions you have. There were tons of them after the paid family leave webinar that we hosted about a month ago. And so we wanted to kind of do a follow-up to that to make sure that everyone got the information that they needed. So welcome back. I hope everyone had a great weekend and feels rested and ready to tackle this week. All right, I'm going to turn it over to Ava actually to run this segment because she knows so much about this. So Ava, I'm going to pass it over to you.
Good morning, everyone. After our paid family leave webinar, this was about almost a little less than a month ago, we had many questions about legal, legal questions about how you deal with employees, opening yourselves out to any legal liability, any lawsuits. I will add that just a reminder in that paid family leave conversation, similar to other state and federal entities, you do have an obligation as an employer to comply with state and federal laws. So anyone who is a center director, anyone who's a home-based provider who has staff, please don't forget that if you're not familiar with the paid family leave deductions that exist, reminder that the deductions that are being paid into are from the employee. They're not a portion of your payment to them. It's the employee who's already earned that money, and you send it to the state of Connecticut and to be compliant. So what I will do is I will add the paid family leave, the employer portion of the information of their website in the chat, as well as the Connecticut Department of Labor. If you're wondering, how do you know if you have to have an employee, if you have staff, and make sure that you're compliant with those types of deductions as well for workers' comp, for Social Security, for any of those deductions legally that you should be paying as an employer because you have staff. Putting that on hold and going to the guest that we have here today, Attorney Livingston is a labor attorney. He is not the typical, like, I'm going to defend you in a lawsuit if you're a child provider lawyer, but he does work for many, many years in labor contracts and negotiations with the state of Connecticut. So he's our invited guest. He's here to answer some basic legal questions because he is an attorney. So get them ready. Well, we're going to look at the Q&A and make sure that they're of the topic of today. So if you have a personal lawsuit between your brother-in-law and yourself, this is not what it's about. So I wanted to make sure that we're opening up to questions about those legalities when you have employees and, some very specific scenarios with potentially parents, so that you're covering yourself and you're not opening up yourself to a lawsuit or to any other legal complications.
Hey, Ava, can I interrupt really quick? I actually forgot. I wanted to give Meryl just a quick chance to give one update before we went into the segment with Danny.
That's great. That gives people
I'm so sorry
time to put in their...
I skipped right over you.
No, Izzy, it gives time for people to put some questions and think things through while Meryl presents. Go ahead, Izzy.
All right, sounds good. Meryl, I'm turning it over to you. My apologies.
Okay, so there are actually two things I wanted to give an update about. Some of you may have seen that the administration released new draft regulations for the Child Care Development Block Grant. We'll have more information about that out on the listserv, hopefully this week. It primarily would reduce copays for parents, which would mean that the state would need to pay higher amounts to providers, or the state would pay a higher percentage of the fee under care for kids. It also changes the payment or encourages states to change the payment processing system and to pay based on enrollment rather than day-to-day attendance. So that is in the works for the whole federal regulation review process. There'll be a comment period, and then the administration has to respond to that. They're trying to finalize those by the end of the year. And then that affects how the state writes its community development block grant plan, how they use their federal dollars and do the Care for Kids program. The other thing that's going on is that Congress is now working on a new federal budget. Congress is kind of a gridlock mess right now. When they passed the debt ceiling increase, they put in some spending caps, and that will limit the amount of spending that the federal government can do. Members of the House Freedom Caucus, or whatever they're calling themselves now, have been pushing to dramatically increase military spending and therefore leave much less available for everything else like childcare. So they are working on their proposals. The House, the Democrats and Republicans trying to negotiate a bipartisan deal. Those are expected in the next couple of weeks. And then in August, members of Congress are in recess, which means they're back in their districts, which means you may see your representative or senator at public events, or you have the opportunity to invite them to come see your program and to talk with them about the importance of that federal money that has come during the pandemic and just generally to support the Care for Kids program. If you are interested in trying to do a meeting with a member of Congress, we're going to try and get some of them to come on to the Zoom meetings, but we won't have time to get all 7 on. So the opportunity to get somebody into your district, please give me a call if you're interested in trying to do that, and I'll help you try and set it up. That's it for me.
All right, thank you so much. Okay, Ava, back to you.
Okay, so I went ahead and I added into the chat the Department of Labor website, the employer portion of the website. I also added the employer portion of the Connecticut Paid Leave Authority. In both sections, there is a multitude of information. You know, for the paid family leave, it talks about how you register your business, how to make sure that you're compliant with deducting the funds, how it actually works, how often you have to deduct. They're pretty thorough. If you don't have a payment processor or a company who does payroll for you, it really does walk you through some videos on how to do it yourself if you're in charge of the day-to-day operations of your own business. If you're a director and you have an HR department or you contract out, then you can share these resources with them and make sure that the person that you're sharing with, the accountant, the bookkeeper, or the payment company knows that they have to be compliant. The Department of Labor website goes into the definition of what is an employee. I know for centers, it's a little bit more straightforward. I have not met a center who's non-compliant yet. Doesn't mean it doesn't exist. But for home-based providers, if you do have an assistant that works full-time, you should be compliant with Department of Labor category of having them as an employee and deduct Social Security and all the multitude of things. If you're home-based and you have an employee that you already do that and you haven't started deducting the paid leave portion, then they were waiving, the Paid Leave Authority was waiving the fine, and they're doing case-by-case scenarios, so you could contact them and have that conversation. If you're a home-based provider and don't have a person in your space helping you 24/7, but instead you have a substitute, then that's where you could really consider 1099ing them, having them as an independent contractor. And if you look at the definition of what is considered employee versus someone who is a consultant or contract worker, you can make that determination for yourself. So I'm going to open it up again to questions, any legal questions that you might have. I know that someone put here in the chat, if I have a staff member that's been in the hospital for 10 weeks, she's not returning to work, what are some options? So, and this is anonymous. I'm assuming that the question is specific, again, to the paid family leave authority option for that staffer. So if you are, if this staff member is 100% categorized as an employee for your team, then you have to make sure that you have the conversation with them to offer them family medical leave. That is federal law. You can't say no if the employer makes that request, to make sure that they have that time that is approved because of a medical condition or someone else in their family has a medical condition. And once it is approved, you could simultaneously, the worker can simultaneously also apply to paid family medical leave. There's two different programs. One's on the federal level and on the state level, guaranteeing that they have a job when they come back from that time off. And then the other program is guaranteeing some income while they have that approved time off. So if I were you, if you're, having this conversation with that employee, then you make sure that you let them know that there are ways to guarantee their employment. There are also ways to guarantee the finances while they're out, as long as it's an approved condition. So if that person in the hospital, if they are indeed sick, then that's pretty self-explanatory, pretty easy to guarantee approval. But there is on the paid family leave website, and I'll also put FMLA, categories of who qualifies. It could be someone who has intermittent needs. Maybe they have a condition that on and off, they need some time to be with, to be attended by a doctor or some time to recoup. It could be someone who has cancer. It could be someone who is just gave birth and they're trying to bond with their child. The categories are pretty clear, and just check them out and hopefully have that conversation with your employee. Hopefully that helps. Okay, let's see. And then Izzy's just reminding everyone to use the Q&A to add your questions here. And hopefully if you have any live questions and you want to be on audio, then you can also raise your hand and we can unmute you so we can hear your voice when you ask your question. If you prefer to be anonymous in the Q&A, there is an anonymous function. So you can go into your chat, ask your question, and then click the anonymous button so it avoids having your name in the record here for today. So just to make it easier I know this is a sensitive question, sensitive information. We don't want to get anyone in trouble here. We just want to make sure that we clarify and assist while people are trying to make sure that their business is being run and all on the up and up. Okay, so if an employee is on CT paid family leave, how long do they have to keep their job open? Does it have to be in the same classroom, or can it be another teaching position? Okay, so paid family medical leave does not guarantee keeping their job open. Paid family medical leave only guarantees payment while they're out. For that said employee to keep their job, this is where it really depends on FMLA, the federal law keeping their job, and the employee filing the appropriate paperwork, but also the employer. So for example, let's say an employee did not file for FMLA and is indeed sick. You as an employer, as a manager, if you don't have a process in place to approve or deny sick time, to approve or deny vacation time, or if you don't have a PTO bank, then you have the discretion if the person's not on FMLA, to have that conversation of like, I can't hold your position. FMLA, if they did file for FMLA and it was approved, then you must keep the position in its entirety. You can't move them from classrooms when they come back. You can't shift them. You can't fire them. But that's only if they applied for FMLA and they got approved for FMLA. Danny, this is where I would come to you for some advice here. So let's say the employer in question, the center director or the home-based provider, does not have FMLA paperwork for that said employee. They have all the right to just fire them and or transfer them into another classroom. Am I correct in this?
So I would be careful about that. The employer will have policies about when someone can take time off, right? And so if that policy complies with state and federal law, it will indicate you can take time off for family medical leave, and will indicate the procedures for seeking time off. It'll indicate communication between the employer and the employee about how to invoke those procedures. The employers are required to be reasonable under all circumstances, not to simply fire a person because they didn't get the paperwork in. So it's not sort of like, well, you call in and say, hey, I've got cancer, clearly a qualifying position, and you forget to file your papers, and then the employer is just safe firing the employee. So yes, you absolutely may require that the medical documentation be filed, but you have to be reasonable in how you require it, or they'll infer that your reason for firing the employee is an unlawful reason.
That's very good clarification. I think that's what people are seeking. On that same wavelength, the two other questions, we have someone asking, if someone has been going to medical appointments and are still able to work, but are missing time due to all the appointments, are they able to get intermittent leave? Yes, there is such a thing as intermittent family medical leave. And again, I will clarify that there's 2 different programs, and then there's 3 different laws. So you have the federal medical leave, then you have Connecticut FMLA. So it's Connecticut's version of medical leave, which Connecticut's very unique because the Connecticut medical leave is longer than the federal medical leave. We just have a program that's more robust than the federal program. And then in addition to that, you have the paid family medical leave. So FMLA and CTFMLA cover that person with their job if they're out on a designated leave. And again, that designated leave, there is a list of what qualifies. The person being sick themselves, really sick is the most obvious, like cancer. And now with COVID, there's been a lot of conversation within these programs of how you qualify. So I don't want to mislead anyone. Please go to their websites. We're going to add them and make sure that employee or if you're interested, that you qualify for those programs. But they're in the FMLA and the CTFMLA, there is intermittent leave. So if you have an ongoing condition, if you're in chemotherapy, if you have, for example, most recently, our air quality was pretty horrible. And there are many people who have, problems with their lungs or conditions that affect their lungs. And they might already be on intermittent leave and would need to take that leave because the air quality was horrible and it was making it difficult for them to do their job. That could have been an example of dipping into their intermittent leave. If there was a previous injury or treatment, again, intermittent leave is, it does exist. It still guarantees your job just like regular FMLA, as long as you qualify, and it has to be approved by a physician. So the next question, if you have an employee who will be non-pay status before the paid family leave payments kick in, can I make an advance to the employee and then deduct the advance once the leave payments are approved? No. So the leave payments, this is such a weird, you shouldn't be in that scenario. So the money that you're deducting from the employee's paycheck every single pay period is automatically being sent. So if you're doing it correctly through the Paid Leave Authority portal, that money's being sent directly to the Paid Leave Authority agency. Like there's a quasi-public agency that oversees this and manages the payment. And that money then, when the Paid Leave Authority kicks in and is approved, then it pays them. I wouldn't dabble into prepaying them to then take it out of their check when you're already supposed to be doing this from a year ago. This to be compliant, all of your employees as of a year ago, you should have been deducting this amount. So there shouldn't really be, if the employee submitted their paperwork on time, then there shouldn't be a delay between your payment and the authority payment. And if there is a small lag, it is retroactive from the date of approval. Okay. Could you link the appropriate FMLA paperwork that needs to be completed by the employee, either federal or CTFMLA? Yes, I could link it onto the chat. The employee filled out for CT paid family medical leave for mental health reasons. She had PTO to cover the first month as of July 5th. She will hopefully receive payment through September. We have a substitute through the summer, but need to hire someone full-time for the start of the new school year. How do we handle that? That is a very detailed question. So the only thing I would say again is the distinction between paid family medical leave and medical leave. And going back to Danny's answer, that if in fact that person did qualify or obviously does qualify for FMLA, to be very careful about denials and backfilling positions. So in all technicality, if they're just on paid family medical leave, you should redirect them to FMLA paperwork as well. If you need to backfill that position in order to keep your classroom open, then definitely backfill that position. What you should be doing, which will help your transition when that person's back at work, is being very clear with that new hire and having a conversation with them about it being maybe seasonal or temporary employment, so that you're not put into a position that when that staffer comes back, the new staffer assumes that they have full-time employment, permanent status employment. If you have an employee handbook that discusses probationary periods, that discuss full-time versus part-time hires, and just make sure that you're looking at your own rules on how you typically handle onboarding someone and onboarding staff, so that you're not opening yourself up to any liability. Danny, you got any backup on that one? That transition between employees?
Yeah, I mean, just a couple of things. The Paid Family Medical Leave Act really didn't change the rules about how long you're entitled to be out, although it did slightly changed the number of weeks in Connecticut effective January 1, 2022 to harmonize. So it's basically now the same as the feds, except for military caregiving. But the essential rules about the right to a leave of absence were not changed. Just the question of getting paid, as Ava said. So that being said, the employer's responsibility is to make sure that when the employee is ready to come back, the employee can come back to the same job or an equivalent job if the same job is not available, if that employee is ready to come back within the leave period. If the employee exhausts the family medical leave, it's only a question of whether the employer has some special promise or commitment that it made in a contract or whatever to give more leave than those typically 12 weeks. But if the employee's 12-week period is over and the employee says, I need another 20 weeks to be out, then that's a decision the employer gets to make, whether to continue to hold the job or not. Or that may be a decision, if it's a unionized workplace, it may be a decision that was bargained with the union. But the law does not require you to hold the job indefinitely. It requires you to hold the job or provide a position when the person's ready to come back, as long as it's within the 12 weeks. So I think in the question that Ava read, it sounded like it might be the person is looking to go beyond the 12 weeks. And then it's a question of making sure you're complying with whatever policies the employer may have or contract, but you're not in violation of law unless you are. There is a separate law called the ADA, which says you can't fire someone because of their disabling condition if that's your intent. But that's not about how long the person's out. That's about your motive, if that makes sense.
Hopefully it does. And if you have follow-up questions to that answer, just pop them in and let us know. In the meantime, I'm going to move to the next one, which I think is solely you, Danny. I have no idea. This one's a little more difficult. Do you have to sign up if your 16 through 18-year-old works for you? Do you have to sign them up? I'm assuming sign up means for as an employee and do all the paperwork to make them an employee. So then it says, I count on on her, so I'm assuming the daughter, count on her for licensing for my state employee bonus. All my kids have worked for me over the years when they're not in school. Is there an age minimum? So several part question. Part number one, if your children are working for you, do you have to consider them as employees? Second part, is there an age minimum as to what age your children have to be to have them working for you? And then the third part is this basically allow? Yeah, if you want to take it step by step there.
Well, let me start by saying we may need to get back to you on. I'm not aware of any special rule for family child care providers in terms of the age of their kids. So we do have a minimum age of employment in Connecticut in general. And in general, if your kids are performing work for you as employees, then you're supposed to, treat them like other employees in general. But there may be some special, particularly working in one's own house. I don't know. So we would have to get back and look and see if there is a special exception for this industry. So we can get back to you on that.
We'll put that on hold for right now. Anonymous said, we are counseled to avoid probationary periods with staffers. Is there a scenario, Danny, that you would know of that you, as an employer, you should avoid a probationary period? I wouldn't know why they were counseled that.
I can explain that. So Connecticut is an at-will state. So those employers who have a policy which says we can fire you at any time for any reason, if you create a probationary policy, you're implying that your at-will policy isn't complete, right? In other words, typically, let's say in a unionized workplace where there's just cause, probation says for the first X months, say 6 months, we don't need just cause. We can just fire you because we think it's appropriate to fire you. But in a workplace that doesn't have just cause, that may be the standard no matter what, even if you've been there 20 years. So management lawyers who are trying to make sure that employees don't have an implied just cause protection in a non-union environment will say you shouldn't have a probation period because that implies that once you pass, maybe there's just cause protection. So that's okay. That's where that counseling comes from. Now there are plenty of non-union employers that don't follow that counsel and feel like they want to have some sort of cause protection for long service employees, and in that case, they almost certainly would have a probation period. But that's where it comes from.
So basically, to better understand this, the minute that they dabble with probationary period, that means that they're giving the workers more protections automatically.
That once the probation period is ended, a worker who is fired might say that there is implied just cause or implied some sort of protection against pure at-will employment, because otherwise, what's the point of having a probation period?
Okay. So, we, Danny and myself can't speak to the advice you've gotten previously when you started your business or the person that you consult with. on a regular basis. But what we could say is in this field of childcare, where we are, constantly battling with making sure that home-based and center-based providers have employees, you have people there, that I think it is smart to consider looking at your own handbook and looking at how you do treat these scenarios, how you treat sick time, how you treat leave and vacation time. If you are more flexible than most employers, that could be another way to maintain your workforce there for a much longer time, considering how competitive and how difficult we are in this field, that it's very hard to find new staff and keep new staff. So, you do what is right for you, but this is, there's no time like the present to revisit those rules and really consider what makes sense for you and for your employees. I'm going to go ahead and put the FMLA application in the chat. So that's the actual portal for FMLA. Again, FMLA is different from paid family medical leave. One pays for the program, one is authorizing time off. I have a question here. Someone wrote, a substitute, a person 20 years of age or older who may assume the provider's responsibilities in the provider's absence, who meets the same qualifications as the provider. Assistant, a person who's at least 18 years of age or older who may assist the provider in the family childcare home while provider's present. So thank you, Gloria. Gloria picked that up from the OEC website, so I appreciate that. Going back, Danny, to the question about Anonymous, about having a 16-year-old staffer, given that there is no special dispensation for OEC to have a 16-year-old, the answer is no.
Well, as I heard the question, that the daughter's performing services, sort of backroom services, not necessarily caring for children. So I don't know whether or not the question of whether you have to be 18 would apply. So that, I mean, I don't want to give an answer when I'm not
don't know the details.
Right.
It's very
but typically well, I mean, typically a 16-year-old can be authorized to work in Connecticut, but the fact that they're 16 doesn't change the fact that they're your employee, even if they're your kid, if you're really having them perform services. But from that 18-year-old rule, you wouldn't want them to be performing the services of a staffer in terms of caring for kids, because that would violate that rule. But whether or not you could be having them fill out paperwork in the back room or typing things on a computer, to save you the trouble, that may not violate the rule, but it still might make them an employee. And that's the part we'd have to check.
And just for clarification's sake here of employee versus non-employee and job duties that the person's performing, regardless of the age, it's about the true role of that assistant, the true role of that caretaker. So if you are on this call and you at any point in your childcare center or childcare home ask your teenage son or daughter or child to clean up, it's been a long day, all of your other employees went home for the day and you just need to clean up a little bit more, and you want to give them a couple bucks to help you clean up, that's not what we're talking about. We're not talking about chores or an extra hand cleaning and disinfecting toys. When it comes to the role of an employee, we're talking about a full, a person in day out, assistant to you, working the full capacity in assisting you. And that's where it gets a little bit more complicated about the designation of an employee versus independent contractor. But as Danny said, regardless of the blood connection to you, if they are performing those real roles, then you should be looking at making them whole and seeing them as an employee. Okay, thank you, Gloria, for that clarification. We
should be careful just about one thing, that one can be an employee regardless of whether they work, 4 hours a week or 40. It's the role that they play, which is, leaving aside the fact they may be your kid, and that's a different question. But in general, if you have an employee come in, someone come in 1 day a week to be your assistant, that's an employee. It's just a 1 day a week employee. It doesn't make them an independent contractor just because they're part-time. Independent contractors effectively run their own business. And so most of the time, when someone comes in and does your work under your direction, or not even most of the time, when someone comes in and does work for you under your direction, they're not an independent contractor, they're an employee. So
okay, that's
if you're
helpful.
telling them, yeah, okay.
Danny, so let's say someone just started their business and they do have that staffer under the header of an independent contractor and are currently not paying a dime into federal or state deductions. The said staffer, who should in theory be designated as an employee, are they open to suing the provider, the childcare center or the home-based provider, or does this open them up more to Department of Labor complaint, or both?
So probably the first and most significant thing is that is the tax law violation. So if you've got an employee, you're paying their share of Social Security, and you're paying unemployment for them, et cetera. Those are all, they're not something the employee would technically sue about, but what would happen is the IRS or the state tax Department of Revenue Services would, in determining that you're the employer, then you will have to go back and pay that employee's Social Security share for them. So normally you pay your share, half of it. The employee pays their own share, right? When you have an employee. But if you have someone that you have misclassified as an independent contractor, you're not paying anything. And when it is found out, you can be responsible for paying both shares for the period in which you misclassify the person. So that alone is a really good reason to not misclassify people, whether you're going to get sued by the employee. So if you're paying the employee enough that you're complying with minimum wage and overtime rules, you may not be violating any Department of Labor rules, because even when they get reclassified, you've already complied, right? You haven't done them any harm as far as the Department of Labor is concerned, but you still would have opened yourself up to a tax enforcement action, which can be quite expensive. When you're talking about paying both shares of Social Security and Medicare for, as long as that person's been your employee, up to 7 years.
So that brings me to another question that we got when we had the paid family medical leave team here presenting. One of the questions that we got was, if I wasn't compliant for the last year with deducting the amount and sending it to the authority from my employee's salary, am I going to get sued? So basically, the authority has a fine and they have a process in place for those employers who are non-compliant. But just because you're non-compliant doesn't necessarily mean that an employee can sue you because of it. That there's different avenues, I guess, from what I'm hearing.
Right. I mean, leaving aside that almost anybody can sue for almost anything, and there are lots of frivolous lawsuits filed, but in terms of lawsuits that have merit, you need to be injured. So if you're just not taking money out from an employee, that you should be taking that 0.5% out because they're an employee, and later that's found out, then it's a matter of how was the employee injured as a result. And if the employee hasn't been injured as a result, there's not a lawsuit that they can file against you that has merit. But you do have to deal with the paid family medical leave folks, and you know better than I do exactly when they're going to start enforcing penalties, et cetera.
Now it's happening.
Yeah,
Fines
exactly.
are happening and they're accruing. So word to the wise, anyone here who has staff, reminder to our paid family leave presentation last month, it has begun. If you are not compliant with deducting from your employees' pay stubs a portion, that one, that's very small percent, and sending it over to the authority, the fines just keep accruing. And then the repercussions are pretty big. Like there are conversations about like holding payment and working with other state entities. You don't want to go there. Just be compliant. Again, it's not your money to keep, it's your employees' money, and you don't want to jeopardize their ability to take that time and get paid for it. So just do the right thing. Back to questions here. What is the difference? Oh, here's an interesting one. If an employee is not returning back to work, and then, so the scenario here, let me just read it and then I'll see if I'm understanding it correctly. What is the difference between unemployment and FMLA if the person doesn't plan to come back? I had a staff go to DR for surgery and plan to take off at least a year. So with FMLA and paid FMLA, it does not last a year. Like we discussed, we're talking about 12 weeks per leave. We're talking about, and then it's both in the details of 12 weeks, you have to be approved. So if in fact this employee is going to surpass that 12 weeks and last a whole year, unless you have something in your handbook or you have something written and confirmed between you and the employee, my understanding, and Danny, you can let me know, they're well within their right as an employer to let them go.
Yeah, so two things. One is I just want to emphasize we haven't been talking about workers' comp here. So if you have an employee who's injured on the job, there are special rules about protecting that employee's right to return to work until they've reached maximum medical improvement. There's a whole different set of rules about workers' comp. So we should put that aside for a moment. But if you're talking about it's not a workers' comp injury, then once that 12 weeks has expired, unless you have some special policy, what the Family Medical Leave Act no longer applies because you've complied with it. And now the rules have to do with the intent of the employer. If for instance, you were to say, I will routinely grant an extension of 12 weeks to people who are, have no particular chronic condition, but if you've got cancer, I'm not going to extend you because I think people who have cancer are whatever. So now you might be discriminating against people who have cancer, which could open you up to a lawsuit under the ADA, Americans with Disability Act. But if you don't have an improper motive and you don't have a contract or a policy which promises more than the 12 weeks, then once the 12 weeks expire, you're not required to hold the person's job.
So if you know beforehand that the person is going to leave for a year, you can walk them through the steps of taking FMLA, taking PFMLA, and then once that time has exhausted and you've complied as an employer with both programs, then you still have to have a conversation with the employee about not coming back and not holding their job, right? Like there has to be some finality to the conversation, or do you just let them go?
Typically employer policies will include contacting the employee after the 12-week period to say, we haven't heard from you that you're ready to return for work. We can no longer hold your job. But that's just trying to create a record to show that the employer's motive wasn't improper. Technically, okay. It's the employee's responsibility to, after 12 weeks, to say, I'm ready to return to work. And if the employee doesn't do that, you don't have to continue holding their job. But it is good practice, as 12 weeks approach, to send a letter and saying, we understand you may not be able to return to work. If we don't hear from you that you are returning, we'll be forced to, fill your position.
Okay, thank you. We have two comments on the Q&A that were an extension of the having your children as assistants or having your children help you in your childcare setting. So for those of you who want to see the comments, they were submitted at 10:01 and 10:05. It's just a comment. So I'll quickly read them, but you could also see what it says. State of approved assistants are 18-year-old minimum. Every employee in a home needs to be approved. So it's a continuation. Stephanie, thank you. It's a continuation of what Gloria was saying on the regs. Everyone here, you're a child care provider. OEC has very strict regulations on age requirements, how many people have to be in the home when you have set amount of children, right? So like for home-based providers, you have that 9 maximum, but the minute you surpass 6 kids, you have to have someone there full-time with you, an assistant full-time with you in order to be at that max ratio. And for center providers, your classroom size really determines how many employees you need in the center space. So please adhere to those rules. These rules are very, very clear, very strict. If you're not compliant with age and staff requirements of humans and adults who could be in that space, then you can be shut down. So thank you for those 2 anonymous and Stephanie and Gloria for your comments. I'm just gonna take them off the queue here. And our last question, Danny, very last question for the day. I thought it was only for full-time employees. So it seems that, Danny, your comment about full-time versus part-time, the definition of what an employee is, I think this is where they're going at with this question. I thought it was only for full-time employees for family child care. If I have an assistant that comes in for my after-school program for 15 hours a week, do I have to enroll her in CT paid leave? I feel like I hire someone and they leave after a few weeks and I have to do it all over again. So enroll them in CT paid leave and 15 hours a work week. It goes back to your comment, Attorney Livingston, that the definition of an employee has nothing to do with the amount of hours that they work. It has to do with the work that they're performing, correct?
Correct. So, and I was really talking about in the full employment context, like whether or not you pay taxes, who pays their Social Security, all those things are determined by who controls their work, not by whether it's a day a week or 8. 8 days a week, I guess, would be hard, but so that's a different question than who you have to sign up for the paid family medical leave, which actually you probably would know the answer better than I would. So
you have to sign up anyone who's designated as an employee.
Right.
One doesn't exist without the other. So if you're again listening to this and wondering, does my staff or does the person coming in to my home or to my child care center to help me with the day-to-day work that I have with children, are they an employee or are they a consultant or are they an independent contractor? You should really look into, are you supervising them? Are you giving them instruction? And then back to what Attorney Livingston mentioned, it's not about how many hours they work, it's about the job duties that they perform and how they perform it. So if you've done some soul searching, you feel confident that they're in fact an employee, then yes, you have to be compliant with CT paid leave deductions and any other deductions, right? Workers' comp, Social Security, federal and state compliance is really important. And then going back to what Danny mentioned earlier in today's call, it's not just about being compliant with these state agencies, it's also about being compliant with taxes and making sure that you don't get dinged from one or the other side.
Yeah, and just to give a sense of scope, what's at stake for the paid family medical leave is 0.5% of wages, which is really just deducting from the employee, paying it over. What's at stake on the federal side could be as much as 15.3% of wages, because that's the full Social Security tax. If you end up paying the full Social Security tax and didn't pay anything because you deemed them an independent contractor, so there's 30 times as much of your money at stake with respect to the tax law side as with respect to the family leave side. So that's really what should drive you, is making sure that you treat employees as employees, because of the consequence if you don't is all that money.
Okay, well, thank you. Go ahead, Mayor.
Just going to say, the difference between like the person who comes and mows a lawn, where they are in control of how they do it, which, they may tell you which day they show up, but they don't, ask you, or you're not telling them you have to weed whack this first, and then you have to mow this first. And then when you're done, I need you to clean up. Yeah. If it's just simply they show up and cut the lawn and you pay them, that's an independent contractor. If it's somebody who's coming into your house and working with you and you're supervising, that's an employee. That's the difference. I mean, if the person has control of how they do their work versus working under your supervision, that's really the test of whether or not they're an employee or am I getting that right?
Yeah, and it's not determined, even if you don't exercise that control because you trust them. So if a person comes into your daycare center and you think they're great, they've been doing it for 30 years, they could do it with their eyes closed, and you say, you know what to do, don't worry about it. That doesn't make them not an employee just because you trusted them. The bottom line is you're in control of how they do their job. Even if you choose not to exercise it because you trust them, they're still an employee.
So back to the example of the son and daughter, and I know many providers on this call have been on Tom Copeland webinars. He's like the tax guru of childcare, recently retired, but he's still pretty amazing, has a blog, etc. Shout out to Tom Copeland. One of the examples in his trainings that he gives on things you can deduct when you're doing your 1040 with your childcare taxes, when you're doing your deductions for your business, is that if your son or daughter or child, if they want to clean up on your behalf and you give them, as technically this is your space, this is your business, you give them a couple bucks here and there, then you're well within your right to deduct it. Now, if your teenage son or daughter is being asked by you to do this more regularly, they could have sanitation toy services and then be an independent contractor. They're not technically, they don't need to be employed by you because they're just cleaning toys once a week, and then that can be seen as a 1040 kind of event. Is that like the distinction?
I lost you for a minute in terms of what you said the distinction was. I mean, Merrill said it pretty well when he talked about, are you in control of how they do the work or just what they do? When you hire a contractor, you're in control of what they do, right? And mow my lawn, whatever. But you don't tell them, this is, I demand you use this kind of lawnmower, I demand you cut it this way and in this order, et cetera. So the child doesn't become an independent contractor just because they do more or less of it. It's a question of, are they in control of what they do and how they do it? And if you're in control of how they do it, then they're your employee.
Okay. Danny, just one more popped up. And I think this is more going back to your answer about if you have a union versus a handbook. But last call here, this last one. If a staff doesn't show up for work, took vacation that wasn't approved, can you suspend or fire them? We don't have a policy that addresses this specifically. They asked for time off, but we had other staff out and didn't approve it, but they took it anyways. From my labor background, they're well within their right to fire them if they don't have a union and they don't have a rule and there wasn't a conversation. But if you want to chime in, Danny.
So the things you're going to be looking at, if you have a union, then you have to comply with the union contract. That might be just cause under the union contract. If having vacation denied and taking it anyway might be just cause. So even if you have a union, you might be in your rights to fire them. Certainly you would be in your rights to discipline them. If you don't have a union, then you're right that it gets to primarily to a question of, do you have some policy written or otherwise, which promises some sort of protections for employees from inappropriate discipline. And if you do, then you have to comply with that policy. If you don't, then we are an at-will state, meaning that the employer can decide, well, I don't like what you did, I'm going to let you go. But most employers will have some policy that applies, and you want to make sure that you that you comply with that policy. The only other thing to say is, remember, there's always discrimination laws which turn on motive. So if you're going to take an employee who took a vacation without permission, and you're going to treat that employee differently based on race, creed, color, gender, national origin, any of those kind of things, obviously you'll get yourself in trouble regardless of what your union contract might say or whether you have a policy. You can't discriminate based on those things.
Okay, well, awesome. Thank you so much, Attorney Livingston, for being on. We really do hope that this was helpful. I know that none of these questions are easy questions to ask. We do appreciate the participation, and on behalf of everyone else who has a question but doesn't feel comfortable asking them, you know, like I mentioned in the very beginning of today's segment, we're in a very difficult time in early ed, right? We're all advocates, childcare directors, childcare home-based providers are really trying to make sure that there is not only survival, but that childcare in early education is thriving. And part of it, making sure it's thriving, is making sure you're treating employees fair and equitable. And I really do hope that some of these questions clarify those doubts and those fears. You know, we have to really strike a balance between doing what's right for your business and making sure that people are not abusing you as an employer, but also you as an employer are fair and just with the rules that you're creating for your staff, and you're treating them you know, as fair and as equitable as possible. So hopefully this is helpful. If you have any follow-up questions, please let us know, and we'll get them to experts that could guide you to that answer. So I'll pass it back to Izzy, and Attorney Livingston, thank you once more for being on today.
Glad to be here.
Great. Thanks so much, Ava. Thank you so much, Attorney Livingston. We so appreciate it. Okay, last call, Ava or Meryl, any other announcements you have for this morning?
Do we have a schedule for the BCIS?
I don't have a BCIS schedule, but that's on me. I have to check in with Charmaine, because she did email me last week. I didn't have an answer for her because next week we have a federal lobbyist coming on, and the week after that we have the Department of Health coming on. So I think maybe Meryl, Izzy, Liz, me, we should talk about when is the best time for BCIS, because I don't know how long they're going to be.
Okay. So
right.
Next week we've got the SEIU national lobbyist.
The national lobbyist. Yep.
Okay. And
John.
And so that's important because Congress right now is trying to put together a federal budget, and that controls how much money the state is getting for the Child Care Development Block Grant that pays for care for kids. You know, we have a little bit more money in some pandemic money that's helping to fill a hole, but we are hitting a cliff of the $70 or $80 million a year that we got from the pandemic to increase the caseload for care for kids. You know, we went from 15,000 children to almost 23,000 children. That money that made that increase possible is coming to an end. And if Congress were to cut the CCDBG grant, that would make it shrink. And that would be a real problem. I think many of us remember how chaotic it was when Care for Kids was closed for 16 months back in 2016, 2017. We don't want to see that happen again. The OEC now has a wait list, and that's supposed to gradually reduce that. But if we were to see a cut in federal funds, that could be a huge problem. So please join us next week.
Great. Thank you so much. All right. And thank you, Attorney Livingston. Thank you, Meryl and Ava, of course, for always knowing so much and being willing to share it with this group. And thank you to Sandra for providing interpretation. And of course, to all of our community who show up every week to learn and grow and join together and just make this whole industry better for Connecticut. So have a wonderful week, everyone, and we will see you next week.